Good morning. I'm Ann Gill, President and CEO of the Tempe Chamber of Commerce. Thank you all for attending our webinar this morning. We're proud to again partner with Gammage and Burnham on an important informational webinar to help us navigate the new questions the COVID-19 pandemic has created for employers and how to address employee concerns. We have three talented attorneys from Gammage and Burnham to share their expertise on these issues and help answer your questions. Rick Mahrle, Chris Raddatz, and Nicole Ricker have joined us this morning, all of whom, by the way, attended ASU at one time or another during their undergrad or postgraduate studies. Gammage and Burnham is one of the most highly respected full-service business law firms in Arizona. Rooted in our state since 1983, Gammage and Burnham remains locally owned and operated and has been a valued member of the Tempe Chamber for more than 10 years. After each presentation, our moderator will facilitate the Q&A from the questions posted in the chat feature. One thing you should know, we typically receive lots of questions and we are grateful and happy to help. The questions in the chat are being monitored by a member of our team to identify the most commonly asked questions and themes. So if we don't get to answer your specific question, we hope that we'll be able to provide you with some direct advice that will help you in running your business and get through these difficult times. So please continue to keep your audio on mute to make this a worthwhile experience for all attendees. And to help get us started and kick things off this morning is Rick Mahrle, who has been with the Gammage and Burnham firm since 1983. Rick is a commercial trial attorney with extensive employment and construction law experience. And when he's not in the courtroom, Rick prefers to be behind the wheel of a classic roadster. So Rick, you are now in the driver's seat.
Thanks. First, on behalf of all of us here this morning, I want to thank the Tempe Chamber for inviting us to share some of our thoughts with respect to some of the issues that we're dealing with daily in these most interesting times. These are the most disruptive and interesting times that I've ever experienced. And for the most part, thankfully, we are all seeing a very strong sense of cooperation and communication with respect to how we're dealing with these issues. And we're all in this together, and we'll get through this to the other side, I can pretty much assure you, hopefully stronger and better at the end of the day. Our program today is going to be divided into four parts, essentially. First, Nicole Ricker is going to talk about issues related to tenants who can't pay their landlord, and then landlords who can't pay their lender, and how we need to work through that. Chris is going to address issues related to the Paycheck Protection Program, and then I'll follow up and discuss some issues about how to manage your now at-home workforce, and also some insurance issues. For example, do you have coverage for some of the losses you're suffering? Well, maybe. We'll look into that. And with that, I'll turn it over to Nicole.
All right, good morning. Thanks, Rick. I have my own at-home workforce with me now. I've got 3 young daughters here working with me, so I apologize if there are any interruptions. I'm going to do my best to make sure that we have an uninterrupted program, but I thank everyone in advance for their cooperation. I'm going to go ahead and share my screen now to give you access to my slides. All right, Rick or Chris, will you just raise your hand if you can see my slide now? Perfect, okay, great. All right, good morning, everyone. I'm Nicole Ricker. I am a transactions and real estate attorney. I work with Rick and Chris, and I am not a litigator. You can probably tell that just by reading the name on my first slide. Maintaining positive and compliant commercial landlord, tenant, and lender relationships in a pandemic situation. It's rather long, but I very much look at the negotiating side of things, and I'm not saying that Rick, who's a phenomenal litigator, doesn't, but I look at, cooperative solutions. And I think because we are all in this together, cooperative solutions are going to be what takes us forward fastest and allows our economy to heal as quickly as possible. So, as everyone has said, these are unprecedented times. We have never before had, in our lifetimes, had a situation where landlords, tenants, and now lenders are all going to be suffering the same hardships. There have been periods of time when we've all practiced and been professionals that certain tenants couldn't pay, that the economy was depressed or recessed. But this is the first time that landlords are suffering the exact same as tenants. Tenants, by and large, in huge percentages, are just not paying, and landlords do still have obligations to their lenders that have not been given, they don't have any relief for those obligations. And so I would just say, whatever your position is, whether you are a tenant rep, a landlord rep, or a lender, I think it's very important to understand that everybody is suffering and nobody has a roadmap for where to go, what to do, and what the right answers are. All right, so let's go to the next slide. Where to start? First place to start is the lease. That's always the first place to start. Lease relationships are contractual. So landlord and tenant's rights arise nearly 100% from the lease document. Even the best leasing lawyers could not have predicted a pandemic. So what we're finding by and large when we go to the lease documents is that there is no exact prescription for what happens now. I have looked at dozens and dozens of leases in the last 3 weeks, and I have not found the word pandemic, contagion, epidemic, and definitely not coronavirus in a single one of them. So it's the first place we start, but what to do next based on the lease is not self-evident. It takes a little bit of digging and a little bit of detailed attention. We will talk a little bit later in the presentation about where to look in the lease and which terms are most likely to provide guidance. Next, whether you are a tenant or a landlord, you want to look to the loan documents. Loan documents are going to have all sorts of obligations about reporting to lenders, about they may have requirements that you maintain a certain financial status. Those are all important things to consider. We have had a few situations in the last week with clients who could have triggered bad boy provisions in their loans for a failure to report to a lender. What does that mean? Okay, so loan documents sometimes say, landlord, in this case, landlord, if you fail to report when tenants go dark or when tenants let you know that they're not going to pay rent, it triggers your personal guarantee. Obviously, that is a very big deal and nobody wants that to happen. So while you're looking at your lease, please absolutely also look at your loan documents and make sure that you are complying to the best of your ability, whether you are a tenant or a landlord. Look for things like reporting abandonments or go darks. I'm not sure that that's what a lot of these closures are, but you should still probably report them. Make sure that if you have experienced a change in your financial status, that you report that if required. And generally, just keep your lender representative a part of this conversation. I think that's a very important step to finding good solutions. All right, so typically, if you were asking me a question about obligations under a lease and some trickle down or trickle up obligations to lenders, we would stop there, right? It's contractual. You're gonna look at your lease, you're gonna look at your loan documents. In unprecedented times, in the situation of pandemic, we all of a sudden have rules and regulations that may impact or affect a party's ability to perform under a lease or a loan. This is rare. This is a very rare situation that we have this, and it is fast moving and changing. I'm going to talk through what we're seeing on the federal, state, and local level in some high level right now, and we'll get into more detail next. So at the federal level, we have not seen much law yet. I think we will. But right now, what we're seeing is guidance. A lot of that guidance has to do with social conduct, social distancing, and hand washing. That does not affect the leases or lease rights. So we can kind of check that one off. Again, only for now. This is all fast moving. State rules and regulations. This is where it gets exciting. I'm going to go into a lot of detail on my next slide about the executive order prohibiting small business evictions. Overnight, our advice as lawyers changed based on that executive order. And so I think that for now and moving forward, state rules and regulations are going to be the biggest game changer for tenants and landlords. Governor Ducey's very involved, and he is making sure, I think, to touch most sectors of our economy and offer guidance. And so he has, and we need to take that into account. Local rules and regulations, again, don't think this one comes into play yet. It may, unlikely. This has to do more with, park closures and recreational closures. So we get to the final place to look, common law. And we will also discuss this in more detail later, but it has been a long time since any leasing lawyer said, let's look to the common law and restatements of law. I mean, this is absolutely a once in a lifetime experience for leasing lawyers. We generally look to our contracts. And sometimes we look to the law to assess a factual situation as it applies to the contract. But common law may actually provide some relief for tenants as we get deeper into this situation. All right, so let's go to the next slide. And I think this just kind of summarizes what I just said. Legal advice on this topic will change over time. We started looking at these issues in March and early April, a really long time ago, like 2 weeks ago. And when we were looking at leases and tenant notices and loan documents and digging for good advice for clients, we were very much relying on the word of the contract. And we were doing that because leases do a very good job of saying who has to do what when. And in the absence of government regulations that contradict those leases, even though we don't talk about pandemic, they do a fine job. On April 7th, Governor Ducey issued Executive Order 2020-21 titled Prohibiting Small Business Evictions. And immediately, everything in our world changed. So if there's one takeaway, there are two takeaways from this talk. I would like for them to be, number one, try to be cooperative and try to see this from all angles. Nobody is unscathed. And two would be, the guidance I'm giving you today will change, and I don't know when. I wish I did, I just don't. The biggest changing forces here will be most likely state law. So keep your eyes peeled, and we may get to do this again. So let's talk about the details of the executive order that prohibits small business evictions. On its face, it seems very tenant friendly. It is also unprecedented. It unequivocally prohibits eviction of tenants that are unable to pay rent because of COVID-related financial hardships. This is pretty packed. It seems like a simple statement. It's rather packed with information, so I'd like to unpack it for you. First, this prohibition is in place until May 31st. Second, although the title suggests that this prohibits only small business evictions, the language in the particular sentence does not distinguish between what the order describes as commercial tenants, which are small businesses, and other tenants. So I think there is some ambiguity, and I think there is some risk in pursuing any tenant. Number three, this applies to tenants who are unable to pay rent due to COVID-related financial hardships. So if you have a tenant who is creating waste, nuisance, in some other way, not carrying insurance, in some other way violating a lease or causing risk, this prohibition does not likely apply to that tenant. This really is meant to be a relief to tenants who have been hit by COVID and are unable to pay rent. So that's the only hard and fast thing to come out of this order. It's the first statement. You may not go to a court to evict a tenant until May 31st. If they are not paying you due to COVID-related financial hardships, one caveat, unless the court feels otherwise. So if there is a extraordinary circumstance, you may have an opportunity to pursue that eviction, but you would need a court mandate to do that. Okay. Who is protected or contemplated by the rest of this order? So it is for commercial tenants. Commercial tenants, as defined in the order, are those qualifying for relief under the Paycheck Protection Program. I am not going to go into detail on that, but Chris is. So stay tuned for more information about that. But this order is meant to relate back to a little bit to the Paycheck Protection Program and say those tenants are very at risk. We would like to help out. And this order is meant to help those tenants, again, who are suffering financial hardship caused by the pandemic. This is not meant to help, or it's not meant to require landlords to do anything extraordinary with respect to a tenant who is habitually or perpetually in default and was not singularly affected by COVID and the pandemic and loss of business. All right, so if you have a commercial tenant, and I'm guessing many of you are a commercial tenant or have a commercial tenant, here is what landlords have to do. Landlords must consider deferring or adjusting rent payments. I'm going to go through all three of these and we'll circle back. So number one, you must consider deferring or adjusting rent payments. Number two, landlords are encouraged to waive late fees, penalties, and interest for late payments. And number three, landlords are encouraged to develop repayment plans for late rent. Again, first blush, this has never been done. We have never had a third party to a lease say to landlords, you should consider waiving rent, you should consider waiving late fees, and we encourage you to amend your lease. But if you unpack it a little bit more, you see that this is really just strong guidance, and in my opinion, I think it's good guidance. This does not say that tenants are excused from paying rent. This is not, as one of our colleagues called it, a rent holiday. This is not a mandate that landlords take any specific action immediately without further due diligence. This, again, is guidance. And so I'm going to go to the next point because I think this is really critical to the conversation about what landlords must do. Landlords should not just take action without considering their loan documents. And I think this is an important piece of the puzzle. Landlords are advised to defer rent or adjust rent, waive fees, and but you are not mandated to do that without consideration to other circumstances. And so landlords must consider their lenders. How are lenders fitting into this? Until this order came out in Arizona, on all the webinars I was on all the roundtables I was on, lenders were standing firm, and lenders' messaging was, you are all business people, you know what you were getting into, you're gonna have to read your loans and you're gonna have to pay back. That was pretty typical advice, and it's pretty historic advice, and it's good advice, right? Like, read your loan documents, make sure you have reserves, make a payment plan. With this order, Governor Ducey said to lenders, if you're lending in Arizona, you have to consider providing an opportunity for your borrowers that are suspending action under this order to have some relief. And again, as with landlords, this is This is a suggestion. This is guidance and advice. Lenders do not have to give landlords a break right now. So, actually, let me back up again. Tenants, what should commercial tenants do? There is guidance in the order too. If you are a commercial tenant that has suffered financial hardship, you should get in touch with your landlord. Staying silent and just failing to pay rent is not a good idea. Never works. And it's not going to make your landlord want to work with you to consider and be encouraged to adjust rent payments or waive late fees. So this should really be a two-way street. Tenants should reach out to your landlords. Landlords should take tenant calls. And if you use this executive order as your guidance, landlords should listen with open ears. Tenants, on the other hand, should do their very best. Tenants should do their very best to communicate with landlords with full and factual information. What do I mean by that? Tenants, landlords have assumed that you are going to have trouble paying rent this month. When you talk to your landlord, you are going to get the best results if you go to your landlord with supporting documentation. Compare your financials from January to April current to your financials from last year, from January to April current. And make sure that you have a mitigation plan. This will come in handy later too. Tenants, landlords, everyone, mitigate your losses. For example, restaurants. If you are able to be open, even landlords, tenants, if you are able to be open, if you're a restaurant and you're able to be open only for takeout, although it may be hardship, if you choose to just close your doors and not try to develop a plan for mitigation, landlords are going to be less likely. Landlords are going to be less inclined and also less prepared to offer you help. Unless you can say to them, by opening only a few hours or for takeout only, I will lose more money. So my advice here is do homework before you ask for concessions as a tenant. Every landlord that I talk to says, I love when a tenant comes to me with a full package of good information so that I'm able to look at it and say, oh my gosh, wow, this tenant has done everything they could do. I want to help them because I think by helping them, they're going to get back on their feet on the backside of this faster. They're going to renew at my location, and we're just going to all feel good about that. That's the best case scenario. Worst case scenario. I bet that everyone has heard the story, but I'm going to repeat it anyway because it's still really mind-blowing. In March, so before Arizona's governor issued the stay-at-home order, large national publicly traded tenants were issuing a letter to all of their landlords that said, hi, these are unprecedented times. We're not going to pay rent. Hope to continue to partner with you. Thanks. We'll be in touch. There are a lot of problems with that, but the biggest problem with that, in my opinion, is that it just made landlords angry. And it really does not leave any room for discussion. To their credit, I have seen a couple of those very big tenants reissue letters that are more specific to a state, to a locality, and the ball is rolling on their leases now. So takeaway from reading the Prohibiting Small Business Eviction order, and also just from dealing with this on a practical basis, tenants, come prepared, bring your landlord a lot of information, do your homework, make a mitigation plan, and landlords, I would implore you to listen and to make financially sound, lender responsible decisions. Landlords, if you have tough loan documents, you may need to get lender consent before you make concessions. Don't forget to do that if you have to do that. Okay, moving on. Other than Executive Order 2020-21, where can I find help? answer is your lease. The first place to look is your force majeure provision. It may also be called an excusable delay provision. These provisions typically provide relief for unforeseeable circumstances. No doubt this is an unforeseeable circumstance. However, and I'm going to skip a slide so that we can get to this conversation, although it generally covers people for their obligation to perform if there is an unforeseeable circumstance that makes it impossible or completely unreasonable for performance, the majority of these provisions in the lease expressly exclude a tenant's obligation to pay rent or perform in any other way that's monetary. So I do suggest, looking to leases, figuring out if the current situation arises, or the current situation becomes a circumstance under which performance is excused. I do suggest making sure that monetary obligations are not carved out. And if you have this kind of protection as a tenant, it may require written notice to landlord. So, you've got to really dig in there and follow the letter of the lease to make sure you can get protection under this provision if it's in your lease. Again, we have got good guidance for this for most things, for strikes, for work stoppages, for war. But I don't think you're going to find exact specific advice for this situation. I do think that we are going to see a lot of litigation coming out on the force majeure excusable delay provision and leases, but obviously that's in the future, and we're trying to provide guidance for what you do today and how you make the best of a challenging situation. Okay, now we go on to a few what I would call kind of dusty concepts, dusty legal concepts as they relate to leases. Again, this is just unimaginable, or it was unimaginable a few weeks ago. And so for the first time in a long time, we're looking at things like frustration and impracticability when it comes to leasing. For a very long time in leasing, landlord had one obligation: give the premises to the tenant, maintain the common areas in some cases. Tenants had one obligation to landlord: pay rent. There were very few circumstances where that was frustrated or impracticable. Pretty easy. We had a very, very wonderful long run of a good economy. So how do we apply these ideas to leases? What is impracticability? Because this has shown up in a number of tenant letters too. Impracticability may happen when events impede performance. And the body of law definitely says regulations and orders are those events. So if a regulation or order impedes performance, a person may be excused under a lease. There are orders in Arizona now, currently the stay-at-home order, that does impede certain performance. Okay. Does it require, or does complying with the stay-at-home order make it impossible for a party to comply with their lease? Well, if it's a matter of paying rent, it does not. Even if you are staying at home, banks are an essential business in Arizona. They are open for business. You can wire money, you can write checks, and you can mail payments. So my current stance on this is that simply paying rent has not become impossible while complying with the stay-at-home order. This may change. As events change, advice here may change. And it's very general advice. It's not client-specific or tenant or landlord-specific. So you may have an extraordinary circumstance that has a different result of analysis. There is a takeaway here, though. If you ever want to say, I cannot perform because of impracticability, you must use a reasonable effort to perform. So this harkens back to earlier advice in my presentation. Mitigate your damages. Be a team player. Do your best during this period of time. If you want to get relief, practically, legally, it is very, very important that all parties, tenants, landlords, and lenders, well, lenders less, but tenants and landlords use their best efforts to perform. Okay, frustration. Kind of like impracticability, frustration is basically a change in circumstance that makes a party's performance virtually worthless. So this flips the script, right? So now a tenant looks to a landlord, and I've seen this too. This is, these are absolutely terms being used in letter correspondence about leases. Tenants are saying to landlords, the change in circumstances has made your performance worthless to me. It is worthless to me to have this space because my business is closed under the stay-at-home order. I can't pay you rent. It's not quite that simple, as you might guess. And frankly, how and whether courts will use frustration to provide relief is currently unknown. There is no playbook for what we are experiencing right now. Generally, in the past, it is not enough that a lease has become less profitable or even that tenant will sustain a loss. The value of lessor's performance must be totally or nearly totally destroyed by the occurrence of the event. In my gut, temporary closures do not rise to the level of frustration. Although businesses may be closed at least until April 1st, maybe longer, it does not totally decimate the value of having that lease. Reopening is imminent, but I don't know when that will happen. Okay, I'm gonna breeze through this one. Another term that is being bandied about in a lot of these tenant letters to landlords is regulatory taking. It's used differently. That's, I guess, a term of art legally, but tenants are saying, by regulation, I am not allowed to operate my business. It's a taking. Government can't do that, but if they do that, we look to the lease, and the lease has some guidance about what happens in the event of a taking. I think it's a little premature to make that argument. Again, the slide that said things will change, I don't know when. At some point, if businesses are closed, if landlords are unable to rent their property, we may have this conversation, but it really requires that a government regulation denies all economically beneficial or productive use of a land. Temporary closures that are in the interest of public health are probably not takings. But at some point, it may happen. If we are not closed for weeks, if we are closed for years, we will do another webinar. Okay. Action items, and I'm going to try to wrap this up so we have time for questions. Tenant action items. If you are a tenant and you are unable to pay rent, first, consider how your business has been affected by COVID-19. Specifically, develop a focused and compelling narrative to share with your landlord and your lender. Second, do you qualify for the stay on evictions in Executive Order 2020-21? If you are a small business that qualifies for protection or relief under the Paycheck Protection Program, you are most likely very protected under Governor Ducey's order. So, using your compelling narrative that you did at step 1, prepare correspondence to your landlord and deliver it to your landlord as soon as possible. The order says that you have to do that, right? So landlords, yes, you're supposed to consider requests, and you should. Tenants, your landlord needs help to consider your requests. So get out ahead of this as soon as possible. After this, if you're a tenant, go do your narrative, collect your documentation, and get in touch with your landlord. Oh, another key point. And this is a key point, acknowledge your obligations. So the order says that as a tenant, you have to acknowledge your obligations for a landlord to engage with you. I think that is good landlord protection, and I understand why the order asks you to do that. I'm almost done. Okay, next, look at your lease. Look for the things we talked about. It is very boring. Don't do it late at night. You will fall asleep, but do look at your lease, see what you're supposed to do. Next, look for correspondence from your landlord. Some landlords have been proactive and phenomenal partners in this. If your landlord is reaching out to you, respond to your landlord. That is your best opportunity to get some relief. And if your landlord hasn't reached out to you, consider talking, instead of sending formal requests, consider talking to a landlord rep that you're close with to figure out what's going on and see what you can do to further that relationship. This is somewhat opinionated advice, but you will have much more success with your landlord if you show them that you're working very hard and you pay them something. If you can pay your landlord something without, without a travesty happening, you should pay something. It's a show of good faith, and you should pay it until and unless you can renegotiate some of the provisions and get deferred rent. All right, moving on. Landlords. If you are a landlord, number one, carefully monitor your tenant's performance. We started doing this at the end of March. Get your property manager, or if you can, drive out to your property. Figure out which tenants are open for business. Are they open full hours? Are they open with limited access? Are they open for takeout only? Find out what they're doing. Next, check your rent rolls. Check your accounts. Are they timely paying rent? Are they fully paying rent? Document this. Next, are you prohibited from evicting tenants under the executive order? If you are, contact your lender. This may actually be in direct violation of your loan obligations. And further advice would really depend on the circumstance, but you need to contact your lender if you are prohibited from evicting tenants, and let them know that you intend to comply with the order if you intend to comply with it, and that you are not forgoing your rights and remedies under the leases, but temporarily you're going to suspend evictions for failure to pay rent if the failure to pay rent is a result of COVID hardship. After you contact your lender, send confirming correspondence, email, letter, something like that. If your loan documents require more, comply with your loan documents. Okay, if you're prohibited from evicting tenants, go back to the earlier slide for basic action items. Talk to your tenants and consider their requests. We are seeing a ton of different solutions to this. Most of them do end up with some deferral, but not excuse from paying rent. And that deferred rent gets amortized over a short period of time once everyone's up and running, or some stipulated time. Okay, last action items, same as tenant side. Understand your leases, know what your obligations are, know what your tenant's obligations are. Be alert for correspondence from tenants. Nothing is more frustrating to a tenant who wants to pay you something or to continue to be a tenant than if your landlord ignores you. And if permitted by your loans, do consider being proactive. There are a number of local landlords who have done a very good job of partnering with small businesses who are doing their best to proactively say to tenants, hey, we respect you, you've been paying us rent for a long time. Although we're hurting too, we have a plan forward. All right, so that was it. I was the longest presentation, so the other ones will be shorter and sweeter. I am very happy to take questions and hope I can answer them.
Okay, Nicole, I had a couple of questions and now I've lost them. Sorry. Okay, so we had a question.
Sure.
So what if we're able to demonstrate financial losses for our business, but our landlord is requesting personal financial information in order to consider helping us, although we do not have a personal guarantee in our lease?
Ooh, that is a really good question. Into this yet, unless there's a personal guarantee and then you are seeing a request for personal financial documents. I would not be inclined to provide that information to a landlord, but I would evaluate the circumstance. I would figure out why they're asking, and probably if I was the tenant in that situation, I would engage the landlord and say, I'm not inclined to provide personal financial information, especially if you didn't provide it when you were negotiating the lease, and if there's no personal guarantee, and find out where they're coming from, why they're asking for that, and make it conversational. I will tell you, in our letters, we are not requesting that of tenants, and so I don't have any anecdotal or historical experience with that in the last few weeks, but I don't have any experience with that. But I would make it conversational. I would not stop the conversation, but I would not be inclined to, without digging further, provide personal financials.
Okay, we had another one. If a tenant's taking the actions that you identified in your presentation and a landlord is still unwilling to consider the request, what do you recommend?
So that it does happen. And I think by and large that is happening. And I think tenants should at least consider that that is happening because the landlord is either in a very tough financial situation or because their lender will not allow them to take action right now. Here's what I recommend. And I say that because it's just a recommendation. Every situation with a lease is so specific. No two leases are the same. But here's what I would consider. I would consider, can you pay anything? And if you can, try to pay what you can. I would consider continuing conversations, watching for new orders that actually mandate certain landlord action. I don't know if that'll happen, but keep your eyes out for that. And I would say the longer this goes on, the more compelling your position may be, and landlord may consider relief. This is all very new. I think landlords will slowly, if they're not already proactively offering help, I think they will slowly start to realize that it's pretty imperative to offer help. They may just be gathering their information and fortifying themselves so that they can later offer help. So bottom line, landlords don't have to do it. They may not be able to do it. So they may not just, they're not trying to be a bad guy most likely. They are just figuring out how they do it and when it's appropriate to do it. At least that's my optimistic approach to things. So I would stay in contact, continue to pay rent if you can, and know that if you are a small business that qualifies under the executive order, your landlord cannot do an eviction action simply for failure to pay rent if it's caused to COVID hardship until after May 31st. So that is your current relief.
The last question I have for you is actually revolving around the PPP loan, and I think Chris is going to get into that a little bit in the next section. But it's talking about the fact that the PPP loans provide business owners the ability to pay rent, utilities, etc. And how would a landlord provide empathetic terms knowing that? Also, the question says, with the news that the PPP loans are not taking new applications, does this provision hold water? So either you can answer that or we can have Chris work on that as well.
I can answer it. So I'll give my answer from the leasing side. Chris, if you want to chime in, just, hand up and I'll mute. So the PPP reference in the executive order is definitional, right? So that we define the commercial tenants who are benefited by the executive order. So whether or not there are new applications or the program continues, that reference is good. So if you are a small business who's qualified under PPP, you have the stay on eviction qualified in the order, but you are most likely protected. If you get money from PPP, you should apply some of it to rent. It is an act of good faith, and the order discusses that if you want your landlord to cooperate, you should cooperate with them. It doesn't say if you get PPP money, you have to pay X% to your landlord or a stipulated amount, but you should apply at least some of that money to rent if you are looking for your landlord to help you. And this again speaks to that whole idea. As a tenant, I think it's incumbent upon you, mitigate your losses, make a good plan, be communicative, be a good steward. And I say the same to landlords, be a good steward, listen to your tenants, but you can't violate your loan documents. So there is a lot of people right now are between a rock and a hard place. I think either the hard place or the rock is going to move slowly as we kind of dig in here. So for right now, there's not a whole lot of guidance and not a whole lot of relief, but there's more now than there was on April 6th. And I imagine that we'll be doing more of these webinars as executive orders and best practices change. Chris, did you want to chime in on this question?
I think I'm muted. Okay, am I unmuted now?
Yes.
Yeah, I will. I'll touch on that as we get into the presentation, because to Nicole's point, definitely as part of the PPP, monies can be used for rent. There are limitations on that, on what can be used for rent. But I would echo Nicole's comment about, if you're working with a landlord, demonstrating good faith. You know, and again, we'll touch on this program. The PPP program, I guess it's repetitive. The program is going to go on, and I'll touch on that, even though the money was out as of yesterday. But I would proceed as if it's going to continue and work with your landlords under that presumption.
Thanks, Chris.
Can I ask Nicole a question? That's
Sure.
right. Nicole, let's suppose I'm a tenant that, because of the shutdown of everything, really can't do business. I'm a gym. You know, I'm not going to be able to find some alternative. I can't do takeout. But the lease says that landlord has to provide me access to my facility. Well, I don't have access to my facility. Isn't the landlord in default?
So that's a good question. I think that the owner of the facility still has access to the facility. They just can't be open to the public. And I think there's some debate about that. But I think that if you are a tenant, as long as you're not open to the public, if you are non-essential, I think you have access to your office. So it's a good argument. It's a tough argument because although you cannot be open to the public, I don't think you're locked out of your premises. And I will say this, and again, we are all solution oriented. Gyms can offer online classes so they can start doing virtual programming. And if I have a gym tenant who shuts their doors, I understand they have to shut their doors to the public. You must do that. I respect that. I'm not going to say that you have abandoned your premises or that you've gone dark, but I am going to say, have you done web programming? Have you thought about doing webinars with personal trainers? What's your plan to reopen? Those are the kinds of things landlords are asking and should ask. Is the landlord in default under the lease? No, landlord is not prohibiting access. It is a regulation. So first of all, I think that the limited people can go into the premises as long as it's not open to the public. And also, I think that there's probably a lease provision that says that tenant must comply with all orders, and that would override landlord's obligation to give possession of the premises. But good question, and I bet there's an exception to that. That's just the general answer.
Great, thank you, Nicole. We really appreciate your guidance and your wisdom. And I don't have any other questions for you from the group, but we can go ahead and answer anything that comes along as we continue the presentation with Chris. So Chris, I'm going to turn it over to you.
Okay, I'm going to try to pull up my PowerPoint here, so give me a second. Let's see. Okay, Nicole, Rick, can you see this? Okay, we're good. Okay. Thank you, Nicole. That was a lot of really good information. Some of it's going to dovetail into this PPP discussion. And I wanted to start by saying that what Nicole was talking about, looking to your lease, look to your loan documents as a starting point to understand how things are going to work for you, in addition to the overlay of the executive order. So you take all that and you completely go 180 degrees when you're talking about the Paycheck Protection Program, because it's brand new. It's entirely a creature of federal law. Well, it's not entirely brand new, but most of it's brand new. And it is part of the Coronavirus Aid, Relief, and Economic Recovery Act that was passed. And it, as many of you know, and I'm going to try to hit on a number of the high points of the program as we go through, and leave some time at the end for questions. My experience so far is a lot of small business owners that can benefit from this have a good idea of some of the general contours of the program, but have business specific questions. So I'm going to try to hit on some of those questions that come up during this and leave some time for some questions towards the end. I have to start with, as we've seen in the news, the application process for this started on April 3rd, and $349 billion was budgeted for these loans. And so the application process opened on the 3rd of April. By April 9th, $100 billion had been approved in loans. Then as of 2 days ago, $324 billion had been approved via 1.5 million applications. And I think if anyone's seen the news yesterday, the SBA notified lenders that it was to stop accepting loan applications on this, that all $349 billion in a period of 13 days had been approved or allocated, if not yet dispersed. And the way the program works is that the lenders, the actual lenders that the small business owners go to, are providing the funds, and it's backed by the Small Business Administration. And the PPP was strongly bipartisan when it was going through Congress. And there is strong bipartisan support to fund additional $250 billion into the program. As of yesterday, there is disagreement in the Senate. The Republicans want to add $250 billion to the program. As it is written right now into law, the Democrats, of course, this could change from day to day, but I think as of yesterday, they wanted to add the same $250 billion, but allocate half of that amount to lenders that are providing funding and loans, to the lenders that provide loans to the disadvantaged community, whether it's economic, minority-owned businesses, veteran-owned businesses, and then they want another $250 billion for states and different provisions that are not applicable to the PPP. Right now, the Senate's out, so we don't expect to see more funding till the earliest next week. But based on the bipartisan support for this program out of the gate, I think that we have this discussion under the presumption that there's going to be additional funding for this program. It's been, as far as government programs go, pretty successful out of the gate. Why is it good? Why is it so popular, and what is it doing? Basically, this is a loan for small business owners designed almost entirely to keep, for an 8-week period, employees on the payroll, to provide funds to do that. The major upsides of the program, most notably, is if you use the funds for the purposes that it's designed for, the loan is 100%, it's completely forgivable. And in addition, unlike other loans, if you have a loan from a bank and a bank discharges it or forgives the loan, typically the IRS treats that as cancellation of debt income. So if you have a $100,000 loan and the bank forgives it, you might have income taxes on that forgiven amount of say $20,000. In this particular case, there's no tax consequences on that forgiven loan. So it's really a win-win for the borrowers who take part in the program. So how does it work? As many of you know, there's an application process. There's an application. It's a short application. It's about 2 pages and contains a worksheet and then some instructions to it. The program, the application asks for number of employees, and it asks for an average payroll. So the way the loan is determined is it looks to your number of employees and it looks to your average payroll looking back to 2019, and you do a simple calculation. And there's variations on that calculation depending on whether you have seasonal employees or whether you've been in business for less than a year. There's some variations on it, but basically the calculation is pretty simple. You come up with a number and you submit that application to your lender. That all sounds easy. I don't think some people have found that in practice. It's been so easy. The reason for that is, as I mentioned earlier, the lenders have to be approved SBA lenders. This program is run through the Small Business Administration. And in a traditional SBA loan, the lender expects the borrower to pay the loan back. So they know where the funds are going to come from, even though it's backed by the SBA. In this program, as we've been talking about, the expectation is the loan will not be paid back, that the borrowers are going to do everything they're supposed to do, use the funds like they're supposed to, and the loan won't be paid back. So that caused a little bit of angst on the part of the lenders up front in terms of understanding, being sure that the program was that they were going to follow the rules, and they in turn were going to get backed, get repaid for these loans that they, the loans that they make. So that goes to the lender approves it, and ideally the loan funds are dispersed rather quickly. And who is eligible for the loan? I know that Nicole talked about this as part of Governor Ducey's executive order. This definition in there about, what did she write down? The commercial tenants, those that qualify for relief under PPP. And that was those were the commercial tenants that the executive order was speaking to. So who qualifies for relief under the PPP? Well, there's general categories. Generally, it's businesses that have 500 or fewer employees. There are exceptions to that rule. A number of important ones apply to the hospitality industry, restaurants, bars, franchisees, restaurant locations that expand the program, but generally 500 employees. There are also other industries as defined by the SBA where you can have more than 500 employees. Actually, I was working with a client recently, a commercial roofing company. Commercial roofers have a special rule under the SBA. I don't know why, but they can have more than 500 employees and still be considered a small business. That small business, that 500 employee rule is subject to some affiliation rules. And it seems to be a pretty big issue for the SBA and as part of this program, because the program is designed to help small businesses. And the affiliation rules are looking at small businesses and try to determine whether they're actually small. And here's what I mean by that. Say, for example, you have a business in Arizona, has 300 employees. You operate a separate business in Colorado. It has 300 employees. There might be common ownership there, but they are two separate businesses. 300 employees, you file two separate applications. You have two qualifying businesses that are qualified for PPP loans. A slightly different scenario we're seeing is perhaps you have a business, and the way you have it organized is you have a management component to it. You have a separate business that does purchasing or procurement, and maybe you have a separate entity that actually does, for example, construction work. And then a separate entity that does management. And the way you set it up for business purposes in separate entities, but ultimately the enterprise is designed to facilitate one business. So even though you have different smaller businesses, collectively you might have more than 500 employees. So there's some questions in the application, and there are some rather detailed affiliation rules to determine whether you as an employer are eligible. You meet that 500 or fewer threshold for employees. The eligibility for businesses applies to limited liability companies, corporations, partnerships, sole proprietors, those people that are self-employed. There's different ways of figuring out your loan amount if you're self-employed, but all of those categories are eligible for the loans. As I mentioned before, the loan amount is based on payroll, a historic payroll, the number of employees you have. And the maximum amount, again, assuming we're going to get more funding, the maximum amount is $10 million. The next question that comes up a lot is obviously the loan is designed to be forgiven. So how is the loan forgiven? Well, the loan must be used for permissible purposes during an 8-week period. The 8-week period starts on the day loan funds are first dispersed to the borrower. And the loan funds must be used for payroll and can be used for rent, mortgage interest payments, some operating expenses. The guidance we've received from the SBA so far, and it seems to be a hard and fast rule, is at least 75% of your loan proceeds must be invested in payroll costs. And payroll costs, a couple things about payroll costs. Payroll costs includes obviously the wages you're paying to employees. It also covers certain benefits that you pay, group health insurance. If you contribute to 401k employer match. So certain of those expenses are considered payroll costs. The payroll cost on a per employee basis, it's capped at $100,000. So, and that applies to wages. So if you have an employee that's at $100,000 plus benefits, that's okay. One of the questions I received, or a variation on questions, is an employer asked me, they said, we take at the end of the year, we do an employer match on our 401k. And we determine that in December, and then in January of each year, we make a lump sum contribution to our employees' retirement plan. Can we take some of the proceeds from our loan and put that lump sum now into their 401k match? And the answer I gave them to that was, no, you can't do that. The rules that we have say if you make as an employer periodic contributions on a per pay period basis to your employee's retirement plan, then you can do that. You can consider that part of the payroll. This is not a lump sum payment payable at the beginning of the year or some other point wouldn't be considered part of the payroll. And kind of a rule of thumb, when these kind of questions have come up about what to count into payroll, I try people to use a bit of a rule of thumb. We don't have, as Nicole had alluded to earlier in her presentation, a lot of this is very fluid. The law is new. The guidance we've got from the SBA, while really good, leaves a lot of open questions. And my general advice has been to tell people, use your judgment. The purpose of the loan is to provide payroll and to keep people on during that 8-week period. And if you think that it's not, then it's probably not. And so similarly to these points, I rolled up in the slide right now. I should have pulled that up before, but I think we've covered these points in here. 75% of the loan must go to payroll costs. 25%, again, going back to Nicole's question about it, you're going to have those funds that you can use for rent payments, and you may want to do so as part of addressing your situation with the landlord. As part of the forgiveness process, in addition to using the funds to pay payroll, the SBA is going to look at how those funds on the back end were ultimately spent. So if you have, to use an example, if you have 20 full-time equivalent employees at the beginning of that 8-week period, there's an expectation that you'll have 20 full-time employees or equivalents at the end of the 8-week period, and that the payroll will be about the same. Not exactly the same. If you don't, if your payroll goes down or if you lose employees, the purpose of the program is not to penalize you, but the amounts will not be forgiven, and there'll be an expectation that the borrower will pay them back. So there's not a penalty, but there's an expectation that they'll pay it back. And the interest rate, as you can see there, is really low, and the borrower has 2 years after the loan is extended to pay it back. So clearly there's an incentive there, if possible, to repay, to use all of the funds for permitted purposes during that 8-week period. One of the questions that's on the application, this raised a lot of questions. It says current economic uncertainty, make the loan request necessary to support ongoing obligations of the applicant. What does that really mean? And it's come up in a couple contexts, because some applicants have come and they've said, well, you know, to use the restaurant example, we can use those funds, we can keep employees on, we're at a reduced capacity, but we can use those. It's necessary to support our operations. In another scenario, and I think that you know, Rick maybe asked the question about the gym, or we deal with clients that have, for example, personal services, a nail or a hair salon, where they don't have the ability to keep on necessarily employees that can work at a social distancing. Are those funds necessary to support ongoing operations? Well, in some cases, maybe not. Maybe there are no employees. And again, the purpose of this program is to provide funds to keep those employees on. And some businesses are just finding that this particular loan program, as good as it is, they don't really have an opportunity to use those funds to keep their activity going, because they don't have anything for the employees to do. So something to think about when considering that application. There are other programs. We'll talk about one towards the end of the presentation about there's an employee retention credit and the economic injury disaster loans. I'll touch on those a little bit towards the end, but there might be other options depending on the circumstances of a particular business. From a practical perspective, we expect, and there's an acronym that's on this particular slide, SIGPR, which stands for Special Inspector General Pandemic Recovery, that's written into the CARES Act. And we expect, and a lot of the guidance we've seen so far suggests that there is going to be careful scrutiny. There's going to be a close look taken at borrowers that accept these funds. So we're advising borrowers, clients, one, I guess at the outset, if you think you qualify and you think these funds are going to be beneficial to you, but you're not entirely certain about the rules, because there are some ambiguities and gray areas in the rules because the program is so new. But if you think you can use it in good faith and use those funds to keep employees, do it, make the application for it, accept those funds, and then in good faith, use those funds to the best of your ability. But we're also advising too that, you know, expect to be reviewed, expect there to be an audit at the end of the program. So one of the suggestions is to use as I wrote in their PPP only bank account. Segregate the assets from the loan you get, set them aside, and then keep careful records about how those funds are being spent. You know, track the payroll, track what you pay to rent or your mortgage or utilities. In terms of a process at the end, well, let me just say, yeah, keep the good records there, keep records of the employees. What you're going to do at the end, and I haven't seen this in practice yet because the program is new, but the lenders that I've seen right now, they're giving the borrowers loan documents, and where the borrowers are in a sense certifying that they are going to keep good records and they're going to keep track of this, because part of the loan process, if you will, is at the end of the period going back to the lender. And I think what borrowers need to understand is the lenders are going to give them loan documents that are going to be very familiar to what borrowers are used to seeing. It's going to contain the loan amount, interest, an amortization schedule, a payment schedule, when those loans need to be repaid. But then there's going to be a carve out for this program and saying at the end, you need to apply back to your lender for forgiveness of loan, for the forgiveness of the loan. And the lender is going to look at it. And that's where you want to have these records in place. Because the lender, if you will, is kind of the intermediary in between the SBA and the borrower. And the lender needs to certify, needs to draw the conclusion that the loan is forgiven, because it needs to go, it should be forgiven, if you will, because it needs to go back to the SBA to get paid and to get reimbursed for that. So think about that at the outset, that you need to keep the records, you need to keep the documents, and be ready for an audit and to work with your lender at the end of the process. I talked a little bit about the Inspector General. Yeah, you know, and there's some language in the application that a number of borrowers have found it scary. There's certification, there's a threat of penalties under federal law of up to $250,000. But, you know, I've been advising clients to take a pragmatic approach. Just the purpose of the program is to keep employees on during that 8-week period. And the expectation for borrowers is they act in good faith in carrying out the program. And I say that, and I don't think that's necessarily a high bar. My recollection is a couple years ago with the Tax Cuts and Jobs Act in 2017, it's not a similar program, but a new government program was implemented regarding opportunity zones. And there was a long time for guidance to come out under that program. And the government said at the time that we know that people are using their good faith best efforts to comply. And if that's the case, you know, we're not going to, the government that is not going to be punitive about that. And everything I've seen so far regarding this particular program is the government's going to take the same approach. There is new guidance. After the program started, we were getting guidance from the SBA practically every other day, clarifying different aspects, answering questions that borrowers had. And the SBA said, you know what, you can rely on the rules as they are as of the day you submit your loan application. And if we change the rules after the fact, we're not gonna hold you to it. We'll hold you to the rules as they are as of the day you submit your application. So let's see here. I wanted to touch on real quickly on this. There's another program. It's another loan program. It's called the Economic Injury Disaster Loan Program. It's separate from the PPP. It's an entirely different program. Right now, it is capped, just like the PPP. It has been tapped out. That slide in there is not correct in terms of the $25,000 as of right now. You can get these economic injury disaster loans up to $2 million per borrower. What's interesting about this particular loan program is you can make application and get an immediate $10,000 advance that never has to be repaid. So you make application, you get the $10,000 within a couple days. You can use it for same things. You can use it for employees, you can use it for rent, you can use it for utilities. And then there's a separate component where you apply for this loan. By the way, the SBA determines what areas of the country are considered economic disaster zones. Right now, the entire country is considered an economic disaster zone for purposes of these loans. But they are loans. So you have to pay, there's an expectation with this particular program, unlike the PPP, is that these loans will get paid back. The interest rate is still relatively low. It's 3.75% for small businesses. There are reduced requirements for personal guarantees, reduced requirements for collateral. So that's another opportunity. Again, the money's tapped right now, but we expect more money for that. And one final thing, there's an employee retention credit. This has not gotten as much attention because if you take a PPP loan, you can't take advantage of the employee retention credit. That's a $5,000 per employee credit that you take on your quarterly payroll return that you file with the government. Again, it's out there. It's, you know about it. I can answer questions on it, but it's kind of taking a backseat to the PPP since you can't utilize both. And then I think I just wanted to turn it over to questions at this point.
Chris, I didn't have any questions come through on the Q&A, and since we're a little low on time, I would recommend that if anybody did have a question for Chris, go ahead and put it in the chat window, and we will address it with the document after the presentation.
Thank you.
Rick?
Yeah, hang on. We need to get Chris's off there so I can share mine.
There we go.
All right. All right, I'm seeing mine on my screen, but I can't see you guys.
We don't see it yet, Rick.
Okay. Now?
No. Are you sharing it with the
Yeah, hang on.
the green button at the bottom?
Hang on. Oh, yeah, that's where I started, but this. Sure. There it is. How about that?
Something's happening. Looks good.
All right, awesome.
You just want to hit play.
Play. Just from beginning?
Sure.
All right.
Perfect.
The way I see it, there are people covering up some of the slide. You guys see the slide clearly without people?
We see the slide. It looks great.
Perfect. All right, thank you, everybody. I'm going to cover briefly in the time I have left to cover a couple of topics. And an important one for many of you is all of a sudden I have employees who are working from home. How do I deal with that? And for some of you, you've already had that, but others, this may be a whole new thing for you. So the issues here have to be tailored to the particulars of your business. You know, people who make widgets, it's pretty easy to determine whether they're being productive because you know how many widgets they're supposed to make in a given period of time. But other kinds of work from home kind of circumstances, it can be pretty difficult to determine whether people are actually being productive or not. So even though your business is going to be unique, there are some best practices you should try to follow. First, it's important to have some kind of written policy in place. You know, what are we going to do about your working at home circumstance? What are your hours? How are we going to measure productivity? You need to emphasize in particular that for people who are hourly workers, who are entitled to overtime, that you make it clear that no off-the-clock work is allowed. All of us, at least in the legal world, are now having the experience of clients emailing us on Saturdays and Sundays and various other times because they don't have much to do anyway, and so they can get back to you. And you know, all of a sudden you're working 24/7 if you're not careful. And it's just the situation we currently find ourselves in. So you also need to make some determinations as to how you're going to measure that productivity and determine how you're going to go about recording the hours worked for those employees who are entitled to overtime. Once again, you don't want to find yourself at the end of this having somebody saying, I was working 26 hours, you know, over the weekend, every weekend while I was, you know, home working. You know, you want to make sure that you're protecting yourself so you know exactly what the circumstances are. You need to issue clear instructions about who has the authority. Who can issue instructions? What are the responsibilities with respect to various obligations? We found it successful at our firm to conduct regular check-in meetings using available video technologies. I think we do it almost every day, just to check with all of our staff who are working from home, making sure there's no problems, making sure everybody's getting covered, that the coverages are adequate. But certainly, depending once again on your business, maybe once a week is fine, but it's certainly not too much. It's a good way to keep everybody communicating. And because of things like Zoom and WebEx and other kinds of systems, you can see each other for the most part, and you can have good discussions. You also need to think about cybersecurity issues. Once again, depending on your business, this might be particularly important. You want to make sure that whatever you're sending over the internet is properly protected, depending once again on your circumstances. Maybe you don't care, but other employers will, particularly for people like in accounting or in the legal world. And document everything you're doing, because this, this may end up being the new normal for a while, but you want to make sure that you're really focusing on paying attention to documenting hours worked. And let me offer a little bit of advice about being proactive. Come December and January, there's going to be a baby boom. And I don't know what your workforce looks like. Your demographics are going to dictate this, but you may want to look at your maternity and paternity policies. Are these going to work when a bunch of people suddenly get pregnant all at the same time? Now might be a time to pull that handbook out and see what do we have in there and what are we offering people and how are we going to deal with that if the predicted baby boom does come about. And I'm pretty sure that it will. All right, so we're going to transition now to issues with respect to insurance. Everybody's getting hurt in some fashion. So the question is, do I have insurance for any of this? Isn't that why I have a policy? Well, this depends entirely on the terms of your policy and your particular circumstances. You have to look at the coverages provided and, more importantly, of course, the exclusions that also might be in your policy. So first place to look, what does my policy say? Do I have coverage for these kinds of events? You also have to look at why has your business been disrupted? Has coronavirus contaminated your facility so that it's no longer habitable? Are you simply a victim of a government-ordered shutdown? Or are you in a circumstance where you couldn't stay open due to a lack of workers or customers? That's all very, once again, issue dependent, fact dependent on your particular circumstances. So what possible coverages might you have? First, you want to look at your commercial property insurance coverage. That's the first party coverage that provides you with protection for damages to your business property. Usually as part of that policy, that part of that property damage policy is business interruption coverage that compensates a business for lost revenues and other expenses if you're forced to close. Think of the example of the fire in the kitchen at a restaurant. Obviously, they can't continue in business. They're going to have interruption of their business. They're not going to be able to reopen until the kitchen is fixed. So that business interruption coverage provides revenue and other expenses while the kitchen gets rebuilt. And theoretically, of course, you should also have coverage for the damage to the kitchen. So the kitchen expenses are also being covered by that property insurance. Because this business interruption coverage tends to be part of or a subset of the property damage insurance, often there is some element of damage to property that is required in order to have this coverage kick in. I've put the typical language on the screen for you. Basically, it's due to necessary suspensions of your operations during the period of restoration. And the restoration is usually been caused by direct physical loss or damage to the property at the premises that are described in the declaration. So you can see the direct connection in most policies between business interruption coverage and the actual damage to the property itself. So you need to determine whether you have direct physical loss or damage in many policies. That's why sometimes the conditions that you are suffering for your particular circumstances are the most important part of this discussion. If you have coronavirus on your premises that makes them uninhabitable, then absent some kind of exclusion for these kind of circumstances, that's a pretty strong case, even if you can't see the damage. There are a lot of cases around the country that have, in the last 20 years, have looked at this issue and have found there to be coverage. There's a case involving the Oregon Shakespeare Festival. There was a large forest fire. The forest fire blew smoke into the facility where they were going to have Shakespeare plays. It made it essentially impossible for them to have a play. The fact of the matter was, of course, that the property itself was not damaged. It was the smoke that was entering into the facility that made it difficult for them to have the plays. Under those circumstances, they were allowed to get the coverage from the business interruption coverage. There are similar circumstances where you've got ammonia contamination, things like that. It's not something that actually has to break the table or burn down the kitchen. It can be other things. But once again, you have to look carefully at your policy. And is being forced to close due to government mandate enough? Well, that may be a harder case, but right now, all over the country, there are cases being filed that are going to deal with this issue and make determination. You may have read about Thomas Keller and the French Laundry up in Napa, and a bunch of other restaurants got together and are suing their carriers over this issue because they've been forced to close by government mandate and they just simply can't do business. So we will see where all this comes out at the end of the day. So keep informed. There is also such a thing as civil authorities coverage. There may be coverage, but a lot of the policy is still required to be some physical damage to property, though not necessarily the insurance policy. For example, there is a tornado, and as a result of the tornado, the electricity is off, or you can't get access to your property, or there's a flood and the river is raging and the bridge that people had to use to get to your property is now being closed because the civil authorities have said you can't use the bridge, it's too damaged. Under those circumstances, there's clearly coverage. But there's also situations where even though there was no damage to the property or the surrounding neighborhoods, where there has been coverage found. Universal Studios Orlando was closed down due to hurricane warnings, even though the hurricanes never came any place close to the park. Didn't even hit Florida, but they were closed down. Under those circumstances, Universal Studios, based on the contents of its policy, did have coverage. So once again, we'll know at the end of this process what coverages are available and what are not. But it's going to take some litigation. In addition to looking at what coverages are provided, you also have to look at the exclusions. As I say in the slide, what the coverage provisions giveth, the exclusions taketh away. There very well may be communicable disease exclusions. There may be bacteria exclusions, but if it's just a bacteria exclusion, coronavirus is a virus, so not excluded there. In recent times, though, because of the SARS outbreak and bird flu and those kinds of things, a lot of policies now have bacteria and virus exclusions. However, some policies actually provide coverage for virus-related losses. It's a known peril that is covered specifically in the terms of the policy. So like I said, you got to look at your policy. There's also a contingent business interruption coverage. This is where you have disruption in your business because of the supply chain. Whoever is downstream from you, you need certain parts in order to do your job. They're disrupted. You can't do your job. You may have coverage there. You don't have to be physically damaged as far as your property is concerned, but often it requires there to be somebody downstream that did have property damage, which caused the disruption in the supply chain. And let me just briefly talk about event cancellation coverage. This is usually all cause coverage, absent some specific exclusion. And the most stunning example is, the Wimbledon tennis tournament has been canceled for this summer. It paid £1.5 million per year for event cancellation coverage to Lloyd's. And it has coverage for the event cancellation, I think the payout is 22 million pounds. So a little bit of foresight can be beneficial. So that's what I have on those two topics. If there are any questions, Suki, let me know.
Currently, Rick, I don't have any questions on this subject. A couple came through for Chris, but I can have him follow up specifically with those folks after the event. So I would once again like to thank all of our attendees and Gammage and Burnham for helping us walk through these turbulent times with our business community. And thank you all for being here today. We're wrapping up right at 9:30. We appreciate your time, and please be safe and have a wonderful rest of your day.
Thank you.
Thank you.